Big Tech Collusion with the United States government, been something that a lot of people have known has been going on for quite some time. We all lived through it. But now, very interesting order came down from a judge that is ordering the federal government to disclose discovery to the state governments that are suing over this collusion. And for a little bit of background here, I want to go over to the Attorney General from Missouri. His name is Eric Schmidt. And he posted this some time ago. In fact, this was a little bit of background for us, posted on September 1st. He says, accordingly, he says, "Hello, America. In May, Missouri and Louisiana filed a landmark lawsuit against top-ranking Biden administration officials for colluding with social media companies to censor free speech." Right? We all saw this. Trump was censored. Anybody who posted any information that was disinformation was censored. People were thrown off of platforms. We were demonetized. We were suspended. The whole thing goes on and on and on. And we were wondering why this was happening. Was there collusion between the tech companies and the government? Well, Attorney General Eric Schmidt says, yeah, maybe. "We have already received documents that show that they had a cozy relationship, and now we're demanding more." He says in July of 2022, Missouri and Louisiana served discovery requests and third-party subpoenas demanding documents from top-ranking Biden administration officials and social media companies over their alleged collusion to suppress freedom of speech. Right? And discovery in criminal cases is typically police reports and body cameras or blood results or, surveillance footage or whatever it is. But in this situation, right, what they're looking for is going to be emails and messages and office memoranda and internal policies and procedures that might show any collusion between the U.S. government and any of these big tech companies. And so they said in July, that's what we were after, these discovery requests and these third-party subpoenas to go out and get it. Now, we fast forward a little bit after they submitted those, the Department of Justice then refused to produce those communications. They said no. Those are all, what did they probably say? National security again? Crying out loud. The most senior officials and the social media companies obviously were communicating, and they said you can't have them. So the states then yesterday filed a joint petition asking the court to compel them to produce those documents, saying, all right, look, the Fauci, CDC, Jen Psaki, all of these administration officials, they don't want to give it to us. Judge, order them to do it. Here's what the Attorney General says. He says, so far, the DOJ identified 45 federal officials who have interacted with social media companies on misinformation, right? And we're going to read the order in a minute. But it says beyond the DOJ, Meta, Facebook, they identified an additional 32 federal officials, including White House officials who communicated with them, and YouTube identified 11 federal officials, including White House officials who communicated with them, many of whom were not disclosed by the DOJ, those stinking liars. They said, I want to know who in the government was working with the media companies, the tech companies. The DOJ gave them a list. They said, oh, we've identified all 45 officials. Here's the full list. And guess what? They didn't give them the full list. Meta said, well, I'm looking at the list of everybody that you gave us. And guess what? We talked to Chuck and Charles and John and James and Jimmy, and they were all over here. And we were working with them, and they weren't on your list that you disclosed to us. Oh. And then they go over to YouTube and Google, and they're like, well, who are you talking to? And they're like, well, I don't know those people on that list, and I don't know those people on Facebook's list, but I know everybody on our list, and it's all these other people. Not disclosed. Now, this sort of reminds me of something. It's like, you've got obligations to provide information. Like the DOJ led an entire raid on the former president because they said, you said that you gave us all your library books and you didn't, therefore raid. So here, the DOJ, right, they're demanded, give us over all of your contact books, right? To make an analogy, give us over all of your contacts on who you were using to communicate with. And they didn't do that at all. They left off, it sounds like 20-something people. So they weren't being very honest, were they? But of course, these things happen. And you can understand how sometimes people might think that, you sort of turned everything back over, and you didn't. And there's miscommunications that happen all the time. But when the government screws up, when the government doesn't give you all of the information or they don't turn everything over to you, it's just a big oops. If you're a private citizen, your home gets raided. Okay, do you see how this works? So the DOJ can essentially lie, right? They know what they're doing. They're in possession of all of this material. This would be the analogous or the equivalent of Brady material in a criminal case. They're hiding their contacts, which is the subject of the entire lawsuit. Not disclosed by the DOJ because they wanted to sweep it under the rug because there's a bunch of liars over there. Attorney General Eric Schmidt says, this is a vast censorship enterprise, and the American people deserve to see the truth. Here are examples that already prove that federal officials and social media companies are coordinating on censorship, and we're not even close to being done yet. He says a senior Facebook official sent an email to the Surgeon General stating, I know our teams met today to better understand the scope of what the White House expects from us on misinformation going forward. The email chain follows the SG's Misinformation Health Advisory in July 2021. Here are these emails. This comes from somebody at fb.com. You can see that up there in the header. It goes from somebody at Facebook to somebody at hhsoash@hhs.gov. Okay, so somebody over there at the Health and Human Services. It says, thanks so much for getting back to me. Really appreciate that. Adding so-and-so and so-and-so to the email so that all to liaise, can see what that word was, to liaise with your office to find a time ASAP, which is convenient for you. I'm in Spain right now, but we can be navigated accordingly. And thanks for reaching out, for sharing your concerns. The last 2 days have been challenging, but let me know if we can schedule some more time to discuss. This is coming from the U.S. Surgeon General. Best wishes, okay? U.S. Surgeon General sending emails over to Facebook about misinformation. And then you see here, it says, I know our teams met today to better understand the scope of what the White House expects from us on misinformation going forward. This is a big problem, right? The U.S. government is not supposed to put its thumb on speech and free speech and censor people at all. And they're doing that. They are outsourcing their constitutional limitations, their prohibitions. They're saying we can't do these things, but Facebook can, and these other entities can. And they're doing it because they don't want the government to have a problem with them, right? They don't want to be hauled in there and subpoenaed and questioned about monopolies or whatever. So they comply. Here's another one. Attorney General says the same official sent a later email to Health and Human Services and noted, thanks again. And here it is, right? Here's a whole nother part of the conversation. Thanks again for meeting with me. We talked about the speech about having to iterate as the pandemic progresses. I wanted to make sure you saw the steps that we took just this past week to adjust policies on what we are removing with respect to information, as well as the steps taken to further the disinfo dozen. We removed 17 additional pages and groups and Instagram accounts tied to disinfo dozen. So a total of 39 pages and groups were removed, deleted thus far, resulting in every member of the disinfo dozen having at least one such entity removed, right? This is literal collusion between the US government and Facebook. Deleting info. We are continuing to make 4 other pages and profiles, which have not yet the removal thresholds, more difficult to find on our platform. Okay, so even the people who are not violating the law or violating the terms of service, they are still suppressing them. Right? We knew all of this was going on, but now here it is. It's right out in the open. More emails back and forth saying we're increasing the strength of our demotions for COVID and certain vaccine-related content. That content will now be demoted at the same strength that we demote other stuff as false. All back and forth with the United States government. Censoring America at the hand of the government. Further communications show that Facebook is increasing the strength of our demotions, and the content will now be demoted along with other content. Zoom meetings back and forth. You can see White House staff is going to be briefed by Twitter on vaccine misinfo. Twitter's to cover trend scene, and they're going to be providing it. And they're going to say how we can partner in product work. The tangible effects, Twitter is notifying them about the tangible effects seen from recent policy changes and what interventions are being implemented in addition to the previous policy changes. literally censoring social media. So you see the list goes on and on and on. Now, this was what we started to get. Okay, this is all coming back on September 1st. All of the juicy meat and potatoes. Anthony Fauci is included in these emails, or at least he's the subject of these emails, his Instagram account. Somebody's pulling off this fake Anthony Fauci Instagram account. All right, so all of this treasure trove of emails are eventually going to be released. But that is coming out from Attorney General Eric Schmidt. And if you want to go follow him, you can see more of those emails. But now, after this lawsuit hit and after the judge started ordering disclosures, we went over to the White House and we started to ask them about this. Hey, Biden administration, you guys are being sued by a number of different states out there. And the judge just said that you have to give information about your communications with these tech platforms over, to the opposing party. And, there's all these allegations being made. Do you have anything to say about this, Karine?
Has the administration helped Twitter and Facebook with talking points about what the administration believes is misinformation, or how much coordination is there between the administration and social media companies?
So I don't have anything to share with you on that.
Comments.
I'm not going to comment on that right this time.
Because the attorney generals from Missouri and Louisiana said there's a vast censorship enterprise across a multitude of federal agencies.
Yeah, I'm just not going to comment at this time.
No comment. So that's the White House. Very, very strong leadership there. A number of states are suing you for violating their citizens' constitutional rights, for colluding with big tech platforms to censor them, demote them, deplatform them, demonetize them, whatever. And you've got no comments on that? Okay, well, that's fine. So no comments from Karine, but we do know that there is more going on in the courts. The judge in the Big Tech Collusion lawsuit issued a 10-page order, and we are going to go through it, ordering the government to comply. You see, the lawsuit is the state of Missouri versus Joe Biden and others, filed back on September 6, 2022. It's a 10-page order, and it's about the discovery disputes, right? We know that these are the two parties here, the state of Missouri, the state of Louisiana versus Biden and everybody else. And there was Psaki on this list. There was Fauci on this list, a whole slew of people. The judges are ruling. They say, the court granted the state's motion for a preliminary injunction related to discovery, and they set an expedited discovery schedule, meaning that this stuff needs to be disclosed soon. The discovery schedule required the parties, meaning the states and the Biden administration, to meet and confer in good faith about the discovery disputes. So we want Fauci's emails from these dates, and they say, well, you can't have Fauci's emails for any of these dates. Okay, well, we disagree about that. And so we got to put it on a statement, file a joint statement with the court detailing the nature of the remaining disputes. Footnote 1, referencing another docket entry. The parties have done so. Okay, they got together and they said, we want Fauci's and you can't have it. Well, we want Psaki's, you can't have those. And they submitted the joint statement on the discovery disputes. And this ruling is now addressing those disputes. Okay, so they're going to say, okay, you get Psaki's, but not Fauci's, whatever. Background. The judge writes, on May 5th, the states filed a lawsuit against the government. And the state means the state of Missouri, Louisiana, these doctors, Chiardi, Kuhldorff, Jim Hoft, Bhattacharya, and Hines, all suing the government. And they gave us a full list of the government defendants here. You can see all of them. Remember all these people? A lot of big names on here. Joe Biden, Vivek Murthy, Xavier Becerra over at the DHS, Anthony Fauci. Yeah. We've also got Alejandro Mayorkas, DHS, Jen Easterly, cybersecurity, Nina Jankowicz over at the Disinfo Board, former, and others were all listed as the defendants. So then they tell us, the judge, in the complaint that the states filed against the Bidens, plaintiffs allege, states say, that the Biden administration colluded with or coerced social media companies to suppress disfavored speakers, viewpoints, and content on these social media platforms by labeling them disinformation, misinformation, and malinformation. And we got hit with, I think, all of them. Plaintiffs allege the suppression, so the states say that you suppressed their viewpoints and all of this type of content constitutes government action, and it violates the freedom of speech and the First Amendment of the United States. 100% accurate, in my opinion. 100% a state actor, because these are the governments leaning on these big tech companies. Very brief background before we get into the meat and potatoes. Discovery disputes now. The parties, Biden and the states, have made a great deal of progress regarding the discovery. However, there are a few ongoing disputes that we need to settle here. Number one, whether the states should be allowed leave of court to file a second amended complaint adding defendants, newly identified federal officials and agencies, and obtain discovery against them. Okay, so they're saying here that the states have listed all of these people under footnote 3, but they want to add a bunch more people. They're like, holy moly, Judge, you said we can get discovery? All right, well, we want to add like 1 million other people to this list. So can we do that? And of course, the government is saying, no, hold on a minute here. The Biden administration, no, you put your list here. It's like you played your cards. You don't get to add anybody to your cards. Okay, you went to the buffet one time. You don't get to go back multiple times now. All right, take it easy. And so, of course, they want that. And so, they're going to fight over it. Number two, whether the Biden administration should be required to identify federal officials and agencies that they know outside of their own agencies who have engaged in communications with these social media platforms. So whether they have an obligation to duty, okay, so whether they're talking about the CDC, they're talking about Department of Homeland Security or the White House. Do they have to go outside of the CDC and go find other things? Do they need to go appoint some sort of a person to lead an investigation that's a little more thorough here? We don't know. They also say that we have a dispute over whether the government, the Biden administration, should be allowed to seek reciprocal discovery against the states. So can they go and say hey, states, we want to see if you communicated with the big tech companies. Hey, Louisiana, did you communicate with Zuckerberg about this stuff? Because if you did, then maybe you don't have as much of a complaint against us because you were also violating constitutional rights or something. Number 4, another dispute about whether the White House defendants, okay, so people like Karine Jean-Pierre, who's on the list, and Chief Medical Advisor Fauci, she calls him Dr. Fauci in here, should be compelled to respond to the plaintiffs' interrogatories and their document requests, right? So does Psaki need to respond? Does Karine Jean-Pierre? They're sort of in the White House, but do they personally need to respond to these things? There's a debate about it. 5, whether Dr. Fauci, in his official capacity, should be required to provide additional responses. Fauci's like, I don't want to talk to you at all. So they have a debate about that. So they carry on, and the judge is going to be addressing these in different subsections. And so you can see we've got the first subsection A is about the second amended complaint. Can the states just start piling on a bunch of additional defendants in there? Can they say, oh my gosh, well, in that case, we'd like everybody from Joe Biden's cabinet. We'd like everybody from Vice President Kamala's cabinet. We'd like Jen's husband's third cousin's emails. Okay. Can we get that, Judge? And the judge says, well, plaintiffs, the states, they allege that they have, through expedited discovery, obtained information that federal officials and agencies that were not named in their original complaint and their amended complaint have also engaged in communications with social media platforms about misinfo, disinfo, and censorship. These allegedly include others, right, outside of that footnote, outside of the named defendants, other agencies like the State Department and the FDA, the Food and Drug Administration, the Census Bureau, the U.S. Election Assistance Commission, and the U.S. Treasury Department, and the Federal Bureau of Investigations, the FBI, also communicating with the big tech companies. We heard about that when Mark Zuckerberg went on Joe Rogan's show and he said, yeah, they kind of came over there and they made us tilt the scale in the Hunter Biden saga. Colluding with all of them. And the states finally are getting notice of this. So it goes on. It says, because none of these agencies or pertinent employees have been named as defendants in this proceeding, the states now are asking the court to expand its provisions and its order to allow the states to add these new agencies and then allow discovery with them as well. government, Biden people, they object to this request. They say additional defendants and more discovery would be incompatible with the compressed discovery schedule that already exists. They say, Judge, how can we bring all these new people on, the FBI and the State Department, when you said that we've got orders to get discovery disclosed at a rapid speed? And if we bring on these new people, well, we've got conflicts here because we then can't comply with your discovery order at that rapid speed. And so the judge says, additionally, government defendants argue that the additional defendants and discovery would exceed the specific target narrow discovery that the states wanted in the first place. The government, the Biden people, they maintain they currently have provided over 15,000 pages of documents, which is certainly a lot. Now, the judge says, expedited discovery is not the norm. The judge says courts only allow it in limited circumstances. We typically don't do this stuff, saying the good cause analysis this court used in allowing expedited discovery takes into consideration such factors such as the breadth of the discovery request, the purpose, how far in advance of trial all this stuff is. They say that this is an expedited discovery request for the purpose of gaining the necessary information to address the preliminary injunction. The court is aware of the burden it has put on all the parties, and to add additional expedited discovery during the current schedule would be too much. So the judge is sort of saying, you're kind of right about that. I have asked you to do a lot and do it quickly, and we have to do it quickly because we're talking about a preliminary injunction. It's very early in the proceeding. And so the court is saying, all right, so here's what I'm going to do. The court will grant in part and deny in part the state's request. Here's how they're going to split it. The court grants the state's request to add additional parties to this lawsuit. Okay, so you can add the State Department and the FBI and others. Big win. However, this court will deny the state's request for the additional expedited preliminary discovery as to the new defendants. So in other words, you wanted discovery and you wanted it quickly. I'm going to allow that for the first set of defendants that you originally listed in the original complaint, and they're going to have to produce their stuff quickly. I am also going to allow you to add another set of defendants, but they don't have to produce the documents at the same speed as the first set of defendants. Saying this ruling only addresses the preliminary injunction discovery and not anything that follows. Plaintiffs may file a second amended complaint adding the FBI and the State Department within 30 days of this order. Woo! That's pretty good news. That means that FBI, State Department, and those other agencies listed in there now going to be added to the complaint. Judge continues subsection B. Now the out-of-agency discovery, separate issue. Now we're asking ourselves, does, let's say, the FBI and the State Department, now they're going to be added, do they have to go outside of their agencies and find other discovery or other potential points of contact that we're communicating with these tech companies outside of their agencies? The judge writes, the states ask the court to require the Bidens to respond to interrogatories or to provide information about federal officials at other agencies who they think are communicating with the social media companies. And interrogatories are just a set of questions. It's sort of like a set of interview questions. So what they would want to do is they would want to go, say, for example, they'd want to go to Jen Psaki or Karine Jean-Pierre, and they'd say, hey, Karine, fill out these 50 pages of questions. And in those questions, they would say, have you ever sent a message to anybody who is an employee at Facebook? And then it'd say, have you ever sent a message to anybody who was an intern at Facebook? And have you ever sent a message to anybody who thought about being an intern, 100 times? And then that same set of questions for Google and for YouTube. And they send that out to 1 billion different people. And then they answer all those questions. And then they cross-reference those documents. They say, oh, yeah, Karine said she sent an email to John over at Facebook.com. And that's not on our list anywhere else. And so now we got to go find who John is and what agency was he. Oh, he was talking with, the agriculture division over here. All right. And then you go get their records. And so that's what they're talking about now. Do they have to do that to go sort of weave that web and follow it wherever it may lead? They're saying of whom they are aware engaged in communication with others. Interrogatory number 1, ask the Biden administration to identify every officer, every official, every personnel, contractor, or agent who's ever worked or communicated with any social media platform regarding content modulation or misinformation. Now, the Biden administration, of course, objects to that portion of the interrogatory relating to all of these other agencies. They say that request is way too overbroad, right? It's like asking for everything. It's not narrowly tailored. It's not even closely related to expedited injunction-related discovery. And the government defendant, the Biden, say this is unduly burdensome, right, to require us to go out there and find all of that. The judge says, all right, well, this court does agree with the Biden administration that in an expedited preliminary injunction request under a compressed discovery schedule, that this request would be unduly burdensome. Again, this ruling right now, the judge says, is limited to the pending expedited preliminary injunction discovery request and is without prejudice to any potential request for merits-based discovery further. So the judge is saying, look, like we're in the first inning of this thing. You're talking about like a seventh inning issue, right? Or a fourth quarter play. You're talking about something like that in the first quarter. We're not talking about that right now. So she then says that the plaintiff, meaning the state's request to make them go follow that web, is denied. Judge say you're not going to require them to do that. Now the government has a request. So the Biden people are saying, well, look, Judge, if you're going to give them our emails and our discovery, well, you should authorize additional discovery and you should authorize that we get it from them. Now, the states are objecting to that. Obviously, they're saying, well, why do we need to give them anything? We sued them. Government defendants, they write, says the judge, has not filed a motion to allow expedited preliminary injunction related to the plaintiffs. And the government defendants have not pointed to any justifiable relevance of any discovery. Right? That's good, yes. What do they need it for? Are you suing them? Neither have government defendants set forth any legal defense for this court to allow discovery. So should the government want to pursue discovery against the states, well, they can file a motion with reasons for that request if you want it. And so therefore, the government request is denied. If you want discovery, ask for it or do something for it. Otherwise, no. And now, finally, I think we have subsection D, the White House defendants. So now, what about Karine Jean-Pierre? And she's substituted for former White House Press Secretary Jen Psaki. Shout out to our friend Zulu in the chat. Yeah, I'm probably disappointed on that one. Sorry, Zulu. Psaki got subbed out with Karine. Yeah, well. White House defendants, in accordance with the previous expedited discovery order, plaintiffs served interrogatories and document requests upon the White House press secretary, Karine. Oh, man. And upon Dr. Anthony Fauci in his capacity as chief medical advisor to the president. Poor man. Government defendants have refused to provide anti-interrogatory responses or responsive documents, maintaining that these would be internal communications that would implicate serious separation of powers concerns. The DOJ is complaining about separation of power. It says the states are required to exhaust other avenues for that discovery first before it becomes unduly burdensome and disproportional to the needs of the case. The states say that they have not served interrogatories or documents upon Biden, and they don't seek internal communications. They only want external communications that Fauci and Jean-Pierre sent to the social media companies. They say, we don't want emails between Biden and Jen, or Karine and Jen, or Karine and Biden. We want their emails with social media companies. So it's not internal. The judge says, first, the requested information is obviously very relevant to the state's claims. I mean, Dr. Fauci's communications would be relevant to the state's allegations in reference to the alleged suppression of speech relating to, the lab leak theory of the origin of COVID, and to the alleged suppression of speech about the efficiency of masks and COVID lockdowns. Yeah, pretty damn relevant. Jean-Pierre's communications as White House press secretary could be relevant to all of the state's examples, all of them. And the judge gives us footnote 6 here, listing all of them, page 14, 20, 23, 25, 36, and on. The government, the Biden administration, the judge says, they're making a blanket assertion of all communications to social media platforms by Fauci and Jean-Pierre based on executive privilege and presidential communications privilege. Oh, so suddenly that executive privilege comes into play, isn't it? Very interesting. Now, plaintiffs, the states, concede that they're not asking for any internal communications, only external communications between Jean-Pierre and the third-party companies. Now, this judge finally says, this court believes that the states are entitled to external communications by Karine and Fauci in their capacities as White House press secretary and chief medical advisor to the president and the third-party social media platforms. Oh, that is delicious. Did you see that? It says the court believes that the states, Missouri, Louisiana, and others, are entitled to the external communications by Karine and Dr. Fauci in their official roles as press secretary and chief medical advisor. The White House has waived its claim of privilege in relation to specific documents that it voluntarily revealed to third parties outside the White House. See also a D.C. District Court case from 2013, another one from 1997, another one from 2018, saying that when you send documents outside of your little executive bubble, you're now waiving those claims. The judge references 3 separate cases that support that ruling. The government Biden defendants, they say that the plaintiffs must seek discovery from other sources. Right? You can't get it from us, go get it from somebody else. The judge said, no, that's not how that works. Said, this is an expedited preliminary injunction related discovery. The discovery was opposed by the government defendants. You don't want to give it to them. This is the only chance that plaintiffs will have to get this information prior to addressing the preliminary injunction. So there's no time, there's no ability to get it anywhere else. You got to give it to them. This discovery was tailored to the facts alleged in this case. There was no requirement in this court's order for the states to get this information from other plaintiffs or other sources first. Judge says, additionally, the states have submitted interrogatories and production requests to the third-party social media companies. They've already done that, by the way. And as far as the burden to the White House, it's no more burden than any other discovery request that they've already answered. Okay, you guys have already been responding to them. You've given them what you said, 15,000 documents. And so this is just not much more. Just do what you're already doing. Therefore, the judge rules, government defendants, Karine Jean-Pierre and Dr. Anthony Fauci, shall provide answers to the state's interrogatories and their document requests within 21 days from the date of this order. Oh, how sweet it is. Those emails from Dr. Fauci are going to be coming out hot soon enough. We have another paragraph from the judge, and we're wrapping up, says that the HHS and Dr. Fauci, as the NIAID director, saying, in addition to being named in his capacity as the White House chief medical advisor, Fauci was over there also at the NIAID. Interrogatories and document requests have also been served upon Fauci in that capacity, right? So Fauci was wearing multiple hats, saying that he was the White House medical advisor, but then he'd sort of take that hat off and he'd stop, doing what he was doing over there, walk back over to the NIAID and do whatever he was doing over there, whatever sort of genetic recombination or whatever they do over there. So he's, hanging out over there in both houses. And the judge said, okay, well, we want emails between you and White House correspondent as to your communication with the social media companies. But how about your role as the NIAID? The judge rules accordingly. The judge says, Biden defendants argue that they have already agreed to provide answers on behalf of Dr. Fauci on the various interrogatories. They say that they're amending additional interrogatories in lieu of other things. But the states say that they served interrogatories on Health and Human Services, footnote 8, which is an agency that is over the NIAID, is what they're saying. The states allege that Health and Human Services has effectively exempted itself from the discovery responses by only providing certain responses from certain agencies, right? So what they're saying is Health and Human Services is a big umbrella, and all of these other agencies are underneath it. The Surgeon General's office, the NIAID, the CDC. And they're saying that when they wanted info from the HHS, they got info from these various independent agencies. The states say, well, Meta, one of these companies, disclosed several senior officials outside of those agencies, outside of the CDC, outside of the Surgeon General, outside of the NIAID, but maybe still within that purview of the rest of HHS. saying that they likely engaged in conversations with Meta. That includes the Deputy Assistant Secretary for Public Engagement, HHS's Digital Engagement Team, the Deputy Director of Communications at HRSA, and so on, right? These are all like the social media people that maybe aren't within the actual NIAID or the Office of Surgeon General or the CDC. They might have their own sort of HHS social media group. And they're saying, well, we're going to give you the stuff from within the CDC, but maybe not that other group. And that might be where all the stuff is. You'd expect that maybe the HHS Deputy Digital Director would be doing a lot of communication with the social media companies, if you had to guess. Plaintiffs allege, the states say, that none of these communications were disclosed by the government in answering their discovery request. They left all those people out. Why? Because they were communicating with everybody. The judge continues. Now, as to the Health and Human Services discovery, the Biden people assert that they identified custodians likely to have relevant information, but that they're not required to conduct a search of all 80,000 employees, which is overly burdensome. The judge says, we're on page 9, the court agrees that conducting a search of all 80,000 employees would be overly burdensome. However, the states have identified several HHS employees which have been identified by Meta as being responsive, and they've listed them here, saying in the judge rules, it would not be unduly burdensome for the government defendants to provide this discovery. Therefore, the judge rules, the government Biden defendants shall provide responses to the states within 21 days of this order. And lastly, the final subparagraph about Dr. Anthony Fauci, the judge rules, she says, in responding to the expedited discovery request regarding Dr. Fauci and his capacity as the NIAID director, the government defendants shall provide responses to the states for all of these additional interrogatories no later than 21 days from the date of this order. And all discovery requests that have not been addressed are accordingly denied. And so the conclusion, the judge writes, it is ordered that the discovery issues contained is granted in part, denied in part. Further ordered, more discovery is due within 21 days, signed and ordered the 6th day of September out of Monroe, Louisiana, signed by Judge Terry A. Dowdy, United States District Court judge. And so major victory for the states and the people who want to know what the federal government was doing, who they were colluding with to suppress information. They call it misinformation. We call it opinions and dialogue about issues that pertain to all of us. But as the judge ruled, more emails from Fauci, more emails from the White House press secretary, whether it was Jen Psaki or her substitute, Karine, all of those conversations that they were having with Meta and YouTube and Twitter, all disclosable. And they got to do it quickly. And so we'll continue to follow that case in detail. But after the order came out, the White House was asked about this. Karine Jean-Pierre, press secretary, asked by somebody in the media, said, hey, you just got ordered to disclose all these emails that we know you really don't want to disclose. Do you have anything to say about that, Karine?
So a federal judge talked about the social media lawsuits from Missouri and Louisiana. A federal judge ordered that you have 20 days to turn over emails communicating with social media companies over misinformation and disinformation. What are those emails going to show? What kind of communication?
So I can't comment. You asked me this question last week. I can't comment on any specifically ongoing litigation. And so again, we would refer you to Department of Justice. A couple of things that I would say on just
no comment again. The first time that she got asked about this, there was no comment. Now it comes up again, still no comment.
As a general matter on this, as we've said over and over again since the beginning of the administration in our battle against COVID-19, it has been critical for the American people to have access to factual, accurate, science-based information and ensuring that any media platforms have access to latest information on a once-in-a-generation pandemic is something that has been done since the earliest days of the pandemic.
So it sounds like she's confident that her information was very good and accurate, and she wanted to make sure through her administration that you got the most appropriate information, even though a lot of that information that they were trying to shove down our gullets has suddenly been proven not accurate. Well, all right. So they were out there. No comments about any of that. I'm sure we're going to learn a lot more when those emails are revealed. This is Senator Rand Paul, who has been all over Anthony Fauci, been making sure that he is held accountable for all of his lies that he's told to us over the years. And now he's reacting to the new order from the court saying that Fauci's emails are going to be made public. Rand Paul has gotten into it with Fauci many times over the years in Congress and outside of Congress. And he's been somebody who's communicated about all the nefarious misdeeds that were taking place within the NIAID. And here he is explaining how much money in terms of profits that they received as a result of, well, what they sold all of us.
Senator Rand Paul of Kentucky is a physician who joins us now. So I think we're just going to see a mountain of communications from Fauci, the White House, to Zuckerberg, to Twitter. And this is just the tip of the iceberg. What are you expecting?
You know, I think that all of America should be appalled that America's doctor, the leading expert on COVID and public health, doesn't want to divulge information, doesn't want to divulge his communications with big tech. But it goes even beyond that. The last time I had him in a hearing, we told him that through freedom of information, we discovered that 193 NIH scientists had taken, no, it was 1,800 scientists had taken $193 million in royalties. And his response was, not that I'll look into it and I'll reveal it. His response was, by law, we don't have to tell you.
And we covered that hearing in detail. And Fauci sat there with his smug little face and he said, well, we kind of just do these things. You know, these are hardworking people and they make deals and sometimes they get profits.
Which companies gave us how many royalties and to which scientists? So this is a guy that his modus operandi is to cover up and try to not allow any sunshine on any of his activities. That should be a tip-off as to his motives.
It sure does.
And Anthony Fauci, we all know, is going to be retiring soon. Many people speculating that is to get out of the blast zone, doesn't want to get caught when the Republicans are back in charge. And we can see why. Well, there's a lot of money being floated around here. And now Fauci is making some new claims about what we have to do in order to be good citizens and following the science. And of course, you can go follow that along elsewhere. But the big tech lawsuit will continue on. We will continue to cover it. Now, this discovery, once it is unveiled, I'm guessing that it's going to be just wrapped in a big, stinking mass of documents. And so it will take a lot of heavy lifting to unpack that, unravel that, and see where all this nefarious lies. But we'll certainly do that here. And I appreciate you subscribing, sharing this video, liking this video, and joining us as we continue to cover all of this wild stuff taking place in our government.